Hello guys, good afternoon. I am Attorney Matias Monico G. Palu-ay, and we are in Obligations and Contracts. We are now in Chapter 2, Nature and Effects of Obligations. This is from Article 1163 to Article 1178. I'll send you the copy of the PowerPoint in the group chat. Okay, so you have a copy of it. So 1163, Article 1163. Every person obliged to give something is also obliged to take care of it with the proper diligence of a good father of a family, unless the law or stipulation of the parties require another standard of care. So what you have to remember when you talk about obligations is that, the law in general is that it's always broken down into two parts. The first one is the general rule, and then the second one is the exception. So in this case, if we read this, every person obliged to give something is also obliged to take care of it with the proper diligence of a good father of a family. And then you cut it there, okay? That's the general rule. So if you do not understand that, what I recommend you do is you translate that in Tagalog. So ang ibig sabihin yan is lahat ng tao na may obligasyon na magbigay ng isang bagay ay obligado din na alagaan ito. I don't really know kung ano yung Tagalog ng proper diligence of a good father of a family, pero imagine yourself as a father of a family, and imagine the care that you will provide your family, your spouse and your children. That's the same amount of diligence that is required when if you are going to deliver something. Okay, so we're talking about the diligence or the standard of care, and that is the diligence of a good father of a family. Okay, but there is an exception to this rule. That is if the law or the stipulation of the parties require another standard of care. So ano ba yung mga ganyan? Ano ba tong exception na ito? I'll give you an example, and we will jump to transportation law. So it says here, unless the law. So ano bang law yan? I'll jump to transportation laws, and specifically the contract of a common carrier. Pasensya na kayo, medyo lumayo na tayo, pero gusto ko lang maintindihan ninyo. Ang common carrier kasi yan yung mga jeep, mga taxi, mga barko, mga eroplano, mga bus. Ang definition yan, if I remember correctly, is that ang obligation ng isang common carrier is to transport the passenger or the goods the passenger from point A to point B safely. And yung required amount of diligence na required sa kanya, hindi lang proper diligence of a good father of a family. Ang diligence required sa kanya is extraordinary diligence. Bakit? Syempre kung nagpabaya siya o nalingat lang siya ng konti, edi yung bus na kung driver siya ng bus, baka na ano na yun. Kumbaga, have you ever gone to Baguio? 'Di ba? Napaka-dangerous ng mga kalsada doon, malingat ka lang ng konti, baka pwedeng lumipad na yung ano mo, yung bus mo sa mga ravines or sa mga creeks, edi deads na yung mga passengers including yourself. So yung required amount of diligence there is is extraordinary diligence, lalong-lalo na sa mga ganyan, sa mga common carrier, sa mga piloto o kaya sa mga captain ng barko. Magkamali lang sila, that will cost lives, millions and millions of pesos, not just pesos but even dollars. Okay, so or let's go to the other half. Unless the law or the stipulation of the parties require another standard of care. Ano ba yung ibig sabihin ng stipulation of parties? Well, ang ibig sabihin ng stipulation of parties is kung ano ba yung napagkasunduan ninyo na standard of care para doon sa particular obligation na yon. So depende na yun sa pag-uusap ninyo. Alright? Okay, let's go to the next slide. Okay, this provision refers to a specific or determinate thing. Every person obliged to give something is also obliged to take care of it with a proper diligence of a good father of a family. So it says here that this provision applies to a specific or determinate thing. A specific or determinate thing is separate from a generic or indeterminate thing. So, ang tatandaan nyo lang dito kapag sinabing specific, it's one of a kind. Wala nang iba. Yan lang ang nag-iisa. One of a kind. Alright? Ano ba example ng mga specific thing? Well, kung sasakyan, a car with plate number ABC 751, ganon. Very specific siya, one of a kind. Or with chassis number, and then you specify the chassis number. Pag sinabing car lang, well, that's generic. Pag sinabing Toyota car, generic pa rin yun kasi maraming Toyota car. O red Toyota car, maraming red Toyota car, so generic. Red Toyota Vios car, o generic pa rin yun kasi marami pa rin red Toyota Vios car. Red Toyota Vios car model 2020, still generic yun kasi maraming ganung model. Red Toyota Vios car parked in the parking lot. Posibleng maging generic pa rin yun kasi lalong-lalo na kapag yung parking mo parking ng SM Mega Mall. Napakadami nun, 'di ba? So, ang generic, yan yung madami, identified by its genus. Okay? So, pwedeng hindi lang siya nag-iisa. Unlike yung specific, yan yung one of a kind. Alright? Para hindi kayo maligaw, tandaan nyo lang parati, specific thing refers to one of a kind. Nag-iisa lang sa buong mundo. Okay. Nandito pala yan, no? In-explain ko na. Specific means something which is particularly designated or physically segregated from others of the same class. A Toyota Vios car with plate number AKW173 or my car, well, this is specific kasi isa lang naman yung sasakyan ko pero kung siguro mayaman ako, pag sinabi kong my car, posibleng maging generic yan kung halimbawa meron akong 10 sasakyan, di ba? Kahit sabihin na natin 3 o 5 yung sasakyan ko, pwede pa rin maging ano yan, generic. Yung generic car or indeterminate, something which refers only to its class or genus. A car, a red Toyota car, a Toyota Vios car, those are all generic. Okay, don't be confused guys ha. Simple lang naman ito. What are the duties of a debtor and an obligation to give a determinate thing? So, sino ba yung debtor? Ang debtor ay yung may obligasyon na gawin ng isang bagay. So, yun yung debtor. Hindi naman necessary kapag debtor ka, ikaw yung may utang ng pera. Okay? So, erase natin yun sa ating mind na kapag sinabi mong debtor ay yung tao na may utang na pera. Hindi. Ang debtor ay yung taong may utang ng isang obligasyon. Okay? Posible yung obligasyon na yun ay pagbabayad ng utang ng pera. Pero posibleng ang obligasyon na yun ay pagdi-deliver ng isang item. Okay? Hindi lang limitado sa pera. Number 1, preserve the thing. The debtor has a duty to take care of the thing with the due diligence of a good father of a family. We discussed this a while ago. Number 2, deliver the fruits of the thing. Number 3, deliver the accessions and accessories. Number 4, deliver the thing itself. And number 5, answer for damages in case of non-fulfillment or breach. Okay? So, we will discuss this later. Yung mga deliver fruits, etc. Okay. So, nandito na kaagad tayo sa fruits na. The creditor has the right to the fruits of the thing from the time the obligation to deliver arises. However, he shall acquire no right over it until the same has been delivered to him. So, ang ibig sabihin yan, may right na yung creditor doon sa kung ano man yung mga fruits nung item na i-deliver sa kanya. Halimbawa, sabihin natin dapat i-deliver sa kanya yung bahay, tapos yung bahay na yun may puno ng mangga. Okay, so i-deliver dapat sa kanya yon ngayong araw. Tapos ngayong araw nagbunga na siya ng mga mangga. Kaya lang yung bahay na-deliver lang sa kanya. Sabihin natin na transfer lang sa kanya nung may-ari 1 month thereafter. Ang tanong is sino ba yung may-ari nung mga mangga doon sa puno ng mangga? Yung original na may-ari ba o yung buyer o yung creditor? According to this article, yung creditor yung may-ari kasi yung obligation to deliver the house has already been existing even 1 month prior. Okay? So, hindi naman niya kasalanan na hindi dineliver sa kanya. Pero may karapatan na siya doon kasi dapat as early as last month pa, nasa kanya na yung possession ng bahay. Ownership and possession. So, there are 3 kinds of fruits. The first one is a natural fruit. Yan yung spontaneous product ng soil. The young of the animals. Example, grass. Plants produced on land without intervention of human labor, babies or of animals. Number 2, industrial fruits. Those produced by land through cultivation or labor. Example is sugarcane and palay. So, I am from Iloilo. Ang main produce ng Iloilo is palay. And I've also been to Bacolod, which is just a 1-hour ferry ride away from Iloilo. That's in Negros. That's Bacolod. Their main produce there is sugarcane. Okay, so ito yung mga industrial fruits. Okay, so madali lang naman intindihan yung natural fruits and industrial fruits. Yung civil fruits, ito yung medyo legalistic. Those derived by virtue of juridical relation. So, for example, is rents ng building. So, halimbawa, bumili yung isang buyer ng isang building. Okay, so yung building na yan, may mga tenants yan. Okay, so sabihin natin, ang bili niya sa building is 100 million pesos. Hindi ko lang alam kung magkano ang presyo ng building, pero syempre parang siguro mga ganyan, o baka nga mas mataas pa. Hindi ko alam honestly. Okay, so may mga tenants yon, tapos sabihin natin na ang delivery sa kanya ng building ay January 1, pero na-deliver lang sa kanya nung June 1, so may 6 months na pagitan. Yung 6 months na yon, yung mga kinita doon sa mga tenants, dapat mapupunta yon sa creditor o yung bumili ng building. Kasi dapat as early as January 1, na turn over na sa kanya yung ownership ng building. Okay, kasi nagkasundo naman sila na yung obligation to deliver the building arises January 1 pa. Okay? So, who has the rights to these fruits? The creditor is entitled to the fruits of the thing to be delivered from the time the obligation to make delivery arises. Okay, so ang lagi niyong tatandaan, kapag ang tinanong, sino ba yung mas may karapatan doon sa fruits ng isang bagay? Okay, kung yung puno ng mangga, kung yung puno ng mangga, hindi yung mga mangga, kung halimbawa building or bahay na may mga tenants, edi yung fruits nun is yung rent. Or halimbawa yung mga aso, yung mga puppies ng aso, sino ba may-ari nun? Ngayon, ang pinakatamang sagot dyan is the creditor is entitled to the fruits of the thing to be delivered from the time the obligation to make delivery arises. So, dapat ma-identify mo kung kailan ba nag-a-arise itong obligation to deliver on the part of the debtor. Okay? So, yun yung pinaka-crucial. Okay? Again, sino ba ang entitled doon sa fruits ng mga thing? Ang sagot is that the creditor is entitled to the fruits of the thing from the time the obligation to deliver arises. So, yung pinaka-main issue mo talaga is when does the obligation to deliver arise? Okay, so the intention of the law is to protect the creditor in the event that the debtor commit delay in the delivery of the object. This will be delivery with a Y. Okay, and then let's save it. Kasi nga naman, unfair naman yun sa creditor, di ba? O halimbawa, bumili siya ng mga aso. Tapos, after ng sale, sabihin natin, i-deliver dapat within 1 week. Tapos within 1 week, nalaman ng debtor, uy, buntis pala itong aso. Sabihin na lang natin na nagka-problema tayo kaya hindi natin ma-deliver. O nagka-COVID tayo. Tapos, ang ginawa ngayon ng seller, inantay niya manganak yung aso. After na manganak, dun pa lang niya dineliver. May bad faith siya dun. Kasi, kapag titingnan mo, dapat, dineliver niya na yung yung aso na buntis as early as 1 week, before. Diba? As early as 1 week after nilang mag-enter ng agreement. Ang nangyari, dahil nalaman niyang buntis yung aso, yung gusto niyang mag-profit or mag-take profit dun sa mga alaga na mga puppies, ang ginawa niya, dinelay niya purposely yung pag-deliver dun sa aso. So, may bad faith doon sa part ng debtor. Kaya, iniiwasan yun ng batas. Kaya, may ganitong provision. Kasi the intention of the law is to protect the creditor in the event the debtor commit delay in the delivery of the object of the contract. So, as you can see guys, maganda naman talaga yung logic ng ating ng particular provision ng law na ito is. And I want you to know that when you do study certain laws, I mean all of it, you try to use yung kumbaga yung real life application, and then I want you to use yung common sense ninyo kung bakit ganito yung batas, 'di ba? Does it make sense, 'di ba? So this one, it actually makes absolute sense kung bakit ganito yung ruling ng or yung pag-interpret mo dito. Or not really interpret, but kung bakit ganito yung law. Okay? O next slide na tayo ha. When does the obligation of the deliver, ito yung actually tinatanong ko kanina, when does the obligation to deliver the fruit arises? When does the obligation to deliver the fruit arise? Dapat arise lang to. Okay? Arise. So, generally, the obligation to deliver the fruit arises, to deliver the fruits arises at the same time the obligation to deliver the thing arises. The obligation to deliver the fruits arise at the same time the obligation to deliver the thing due arises. Okay. So, kung kailan mo dapat i-deliver yung item, edi doon mo rin i-deliver yung fruits. Okay? So, when does the obligation to deliver the thing due arise? So, generally, the obligation to deliver the thing due arises at the perfection of the contract. Perfection refers to the birth of the contract. So, the exception here is when there's a specific date of delivery. So, let's pause for a while and let's ask, what are the stages of a life of a contract? Kasi, we just mentioned the word here, perfection of the contract. What does that animal mean? What does that mean? Okay? So, that's very, very simple. Okay, we'll answer it in the next slide. Okay, the 3 stages in the life of a contract is number 1, negotiation. This is where the parties negotiate the terms and conditions of the contract. It includes negotiating the price of an item. In Tagalog, ang tawag dito ay tawaran. Okay, so kung if ever nakapunta ka ng Divisoria o naka-experience ka na tumawad ka sa presyo, ito yung price nun. Ito yung not really price, sorry. Ito yung stage na yon na nagtatawaran kayo. O pwede bang ganito na lang? Okay? Diyan kayo nagne-negotiate. Okay? Sa aking practice, laging nangyayari yan. In fact, today, meron akong kaso. Ang complainant ko ay isang caretaker, tapos he has been with the company for 10 years. So, ang nangyari is tinanggal siya sa trabaho. Ang hinahabol namin dito is like 400,000 pesos na separation pay. So, may back wages pa yun actually, pwede pang tumaas. Pero, for purposes of settlement, nag-convey ako doon sa lawyer ng other party. Sabi ko, attorney, pwede bang willing ba kayo makipag-areglo? Sabi nila, oo. Ngayon, sabi ko, meron ba kayong offer? So, sila yung una nag-throw ng offer. By the way, guys, for purposes of negotiation, it's always better if you let the other party start with an offer. Okay? So, ang offer nila is very low, 100,000 lang. Nag-counter ako ng 300,000 at nag-counter offer sila ng 150. So, ngayon, nag-counter offer ako ng 200. Sabi ko, yan na yung last. Tapos, pinag-aaralan pa nila kung pumayag sila doon, di maganda. Kapag pumayag sila, nag-agree na kami, perfected na yung contract namin for purpose like this one, for settlement. Oo. So, perfected na yung contract, and then ang susunod na mangyayari dyan is yung consummation na. Okay? So, ano ba yung perfection muna? Perfection is simply when the parties agree to the terms of the contract. So, nagkasundo na. Tapos, yung last is yung consummation. So, in this case, in case of a contract, settlement contract or settlement agreement, kasi you have to always understand that a contract is basically just an agreement. Okay? So, you may call it a settlement contract or a settlement agreement. So, kapag nagkaroon na ng settlement agreement, magkakaroon na ng delivery, which is babayaran yung client ko, and then yung client ko naman, ang gagawin niya is mag-execute siya ng tinatawag nating waiver and quit claim. At sinasabi doon is wala na siyang hinahabol sa kumpanya at i-dismiss niya na yung kaso. Well, waiver and quit claim yung gagawin niya, tapos magpe-prepare ako ng joint motion to dismiss. So, pasensya na kayo, medyo technical, pero this is what I do on a daily basis. I run my own law office, and I practice most of the time labor cases kasi napakalapit lang ng aking office sa labor courts dito sa Banawe. Okay? So, next slide na tayo, ha? May ano pala dito. May example. So, si seller, nagbenta siya ng kabayo. Alam mo, nakakatawa nga dito kasi itong PowerPoint presentation at saka yung ating pinag-aaralan is base dun sa libro ni Hector De Leon, kasi napakagaling talaga nito ni De Leon kasi napakasimple ng kanyang mga explanation. Pati yung mga example niya, sobrang simple. Limitado lang yung mga examples niya kung mapapansin nyo sa mga kabayo, refrigerator, o kaya bigas. Puro ganun lang yung example niya. Okay? So, dito, kabayo, horse. Seller sold his horse to B for 15,000. There was no date stipulated for the delivery with a Y. Delivery of the horse. While still in possession of S, the horse gave birth to the colt. So, who has the right to the colt? Yan, napakaganda. Actually, may real life application ito. Kasi halimbawa, kung kayo ay may alagang aso, yung mga dogs na mahal, like yung mga pitbull, okay, yung mga chihuahua, o kahit na sabihin na lang natin hamster, di ba? I-hamster ka. Okay? So, nag-agree na kayo dito. Babalikan natin yung example, ha. The seller sold his horse to B for 15,000. There was no date that was indicated for the delivery of the horse. So, while still in possession of S, the horse gave birth to a colt. So, what's the right to the colt? So, the answer here is B. The buyer has the right to the colt because under Article 1164, the creditor has the right to the fruits of the thing from the time the obligation to deliver it arises. In the present case, the obligation to deliver the horse arose immediately when the parties agreed to the object and the consideration of the contract. So in this case, there was already a perfected contract of sale. So the obligation to deliver the horse arose from the time of perfection. But I think you have to read this in conjunction with honestly the book of De Leon is a bit unclear about this, especially this one, the example here in the book. It says here, tama naman kasi, ang general rule naman kasi dyan, kapag nagkasundo na yung parties, perfected na yung kontrata, pareho kayo ay may obligasyon na kayo sa isa't isa. Pero you have to read this in relation to sales law. Okay, so ano na naman sir, ano na naman yung sales law na yan? Okay, so yung sales law, it's another specified subject or specified field of civil law. So under siya sa civil law ang sales law. And ang naalala ko dito sa ating sales law, kasi itong nasa example natin, I just based this purely dun sa example ni De Leon. Kasi nakalagay dito sa kanyang libro ay this is article 11. Teka lang ha, hahanapin ko muna dito ha, para hindi tayo magkamali. Okay. Ito. In a contract of sale, all fruit shall pertain to the vendee or the buyer from the day on which the contract was perfected. Hence, B is entitled to the colt. This holds true even if the delivery is subject to a suspensive condition or suspensive period. If B has paid the price, but the seller has the right to the colt if it was born before the obligation to deliver the horse arises, and the buyer has not yet paid the purchase price. In this case, the fulfillment of the condition or the arrival of the period, the seller does not have to give the colt, and B is not obliged to pay. So, if you read it here, it says here that in a contract of sale, the vendee from the day in which the contract was perfected is entitled shall pertain to the vendee from the time the contract was perfected. So, base dito, dapat from the time the contract was perfected, si B na yung yung may right doon sa colt. Okay? Kasi nagkasundo na sila eh. Pero actually very conflicting honestly, kasi ang naalala ko naman sa sales law, ang obligation ng seller to deliver will only arise pagkatapos makapagbayad nung buyer nung pera. Kaya I think if we limit yung discussion natin dito sa obligations and contracts, which is nandito lang naman tayo sa oblicon eh. Susundan na lang natin ito para matapos na tayo. Susundan natin yung nakalagay dito sa libro ni De Leon, which is ang sinasabi niya, ang obligation to deliver arises from the moment of perfection. As simple as that. Okay, wag na muna nating talakayin yung contract of sale or kung ano man yung specific law doon sa contract of sale. Okay? So, dito lang muna tayo sa example ni De Leon. The obligation to deliver arises at the moment of perfection of the contract. Kung kailan yung perfection? The time na nagkasundo sila. Okay? When what is to be delivered is a determinate thing, teka lang pause muna ito pala may answer. B has the right to the colt under Article 1164. The creditor has the right to the fruits of the thing from the time the obligation to deliver it arises. In the present case, the obligation to deliver the horse immediately arose when the parties agreed to the object and the consideration of the contract. Hence, there was a perfected sale already. Hence, the obligation to deliver arose from the time of perfection. So, it's really that simple. Okay, Article 1165. When what is to be delivered is a determinate thing, the creditor, in addition to the right granted by him by Article 1170, may compel the debtor to make delivery. If the thing is indeterminate or generic, he may ask that the obligation be complied with at the expense of the debtor. If the obligor delays or has promised to deliver the same thing to two or more persons who do not have the same interest, he shall be responsible for any fortuitous event. Okay? So, let's break this down. So, that's 3 paragraphs. So, paragraph 1, when what is to be delivered is a determinate thing, the creditor, in addition to the right granted by him by Article 1170, may compel the debtor to make delivery. So, here we are talking about determinate or specific things. We are talking about a determinate or specific thing only. This part talks about the right of the creditor in an obligation to deliver a determinate thing. It says that the creditor has a right granted to him by Article 1170. So, ano naman yung 1170 na yan? Okay, so I took the liberty of looking for Article 1170. What are the rights of the creditor under 1170? Simply, the right to demand damages. Okay, so Article 1170 talks about damages. Okay, those who in the performance of their obligation are guilty of fraud, negligence, or delay, and those in any manner contravene to the tenor thereof are liable for damages. So 1170 only talks about damages. So aside from damages under 1170, what are the other rights of the creditor in an obligation to deliver a specific thing? So it's very simple, and you have to remember this, guys, because it's always this always comes out. It's one of the favorite questions by the examiners. The creditor has 3 rights. They are: number 1, specific performance, that is the creditor may compel the debtor to perform the debtor's obligation. Number 2, rescission or cancellation. The creditor may simply cancel the obligation and rescind the contract. And then number 3, payment for damages. So again, that's based on Article 1170. So napaka-simple lang yan. Specific performance is gusto mong ituloy yung pag-uusap ninyo. Rescission is sulian kayo ng kandila. Okay, babalik tayo dun sa ating ating naunang state. Wag mo nang ituloy yan yung gusto mong yung obligasyon mong gawin at hindi ko na rin ito itutuloy kung ano man yung dapat kong gawin para sa'yo. Okay? Paragraph 2, if the thing is indeterminate or generic, he may ask that the obligation be complied with at the expense of the debtor. So this talks about a generic thing. You have to remember that the genus is never lost. Genus non quam perit. The genus never perishes. Well, that makes sense kasi hindi naman siya one of a kind. It is irreplaceable. Parang yung kanta, I need you do. Yun ba yan? Replaceable. Bigla ko lang naisip. So, the obligation will always remain. It is not necessary for the creditor to compel the debtor to make the delivery, although he may ask another for the performance of the obligation at the expense of the debtor. Alright? Okay. Example, for paragraph 2, Article 1165, the seller obliges himself to deliver to the buyer 100 sacks of rice on December 24, 2020. In return, B obliges himself to pay S, the seller, 50,000 pesos. On due date, S failed to comply with the obligation. So, hindi niya na-deliver yung 100 sacks of rice. So, in this case, the buyer may buy rice from C, a third person. If the buyer paid 55,000 instead of 50,000, B may recover the excess of 5,000 from S. Kasi di ba yung original usapan nila ni S is 50k. Tapos, hindi naman tumapad sa usapan si S. So, ang ginawa niya, hanap na lang siya ng pangalawang tao na pwedeng mag-deliver sa kanya ng bigas. Pero this time, mas mahal yung binayaran niya. Instead of 50,000, ang binayaran niya 55. So, ayon dito sa particular article na ito, pwede mo palang hingin or ipa-reimburse yung sumobra. So, in this case, ang sumobra is 5,000 kasi 50,000 yung original tapos yung pinagbilhan niya ng pangalawang beses is 55. So, napagastos pa siya ng 5,000. Okay? Paragraph 3, 1165. If the obligor delays or has promised to deliver the same thing to 2 or more persons who do not have the same interest, he shall be responsible for any fortuitous event until he has effected the delivery. So, here, even if there was a fortuitous event, if the debtor promised the same thing to 2 or more creditors, he shall still be liable. 1166. The obligation to give a determinate thing includes that of delivering all of its accessions and accessories, even though they may not have been mentioned. Okay, so we discussed accessions and accessories already. So, we move to the next. I don't think we have pa pala, no? Okay. I apologize, hindi pa pala. Dito pa lang. Okay, so ano ba yung accessions and accessories? Accession is anything attached to the principal thing, which is either naturally or artificially. Magagamit pa rin yung principal thing whether or not may accession. So, house or trees on a land, air conditioner, and a car. So, kahit walang puno o bahay doon sa lupa, pwede mo pa rin naman gamitin yung lupa. Kung walang air conditioner doon sa sasakyan, pwede pa rin naman umandar ang sasakyan. On the other hand, accessory is anything that is necessary, so kinakailangan, for the perfection, use, and preservation of the thing. If wala yung accessory, hindi magagamit yung thing. Maganda yung Tagalog interpretation ko dito kasi sa totoo lang nakakalito din talaga tong accession and accessory. So yung accessory, kailangan yon, necessary. So, house ng bahay, well, tama naman. Paano mo nga naman talaga may enter yung bahay kung wala kang susi, di ba? Frame of a picture. So, well, syempre, paano mo isasabit yun? Yung picture kung walang frame. And then, bow of a violin. Well, the same logic, paano mo ipi-play yung violin kung wala kang bow? A person is obliged to do something, fails to do it, the same shall be executed at his cost. The same rule shall be observed if he does it in contravention of the tenure of the obligation. Furthermore, it may be decreed that what has been poorly done may be be undone. The obligation consists, Article 1168, when the obligation consists in not doing, the obligor does what has been forbidden him, it shall be undone at his expense. Okay? So, pag sinabi na, wag mong gagawin yan, pero ginawa niya pa din, pwede mong i-undone yun, pero siya yung gagastos. Article 1169, those obliged to deliver or do something incur in delay from the time the obligee judicially or extrajudicially demands from them the fulfillment of their obligation. So, however, the demand by the creditor shall not be necessary in order that delay may exist when the obligation or the law expressly so declares. Number 2, from the nature and the circumstances of the obligation, it appears that the designation of the time when the thing is to be delivered or the service is to be rendered was a controlling motive for the establishment of the contract, or when demand will be useless as when the obligor has rendered it beyond his power to perform. Okay? So again, 1169, this talks about judicial and extrajudicial demand. Those obliged to deliver something incur delay from the time the obligee or the creditor judicially or extrajudicially demands from them fulfillment of their obligation. Okay? So, kailangan munang mag-demand. 1169 simply Article 1169 talk simply of no demand, no delay. This means that you have to make a demand before the debtor can be rendered in legal delay or default. This is only when the debtor is rendered in default that you can actually sue the debtor. If you do not demand, the debtor will never be in delay or in default. Bakit? Kasi the law presumes that you have given the debtor more time to pay you. So, ano ang lesson natin dito? Well, ang lesson natin dito sa particular topic na to is, wag kayong mahihiya. Kailangan ninyong maningil talaga. Kasi kung hindi kayo maniningil, ang interpretation ng law, and lalong-lalo na dun sa umutang sa'yo, binibigyan mo pa siya ng time para magbayad. Article 1169 talks about delay, specifically legal delay. So, what is legal delay? So, legal delay or default or mora. Ang daming term, no? Legal delay or default or mora is the failure to perform an obligation on time, which failure consists of a breach of obligation. So, ano ba? Paano mo matatandaan itong itong legal delay? Siguro, from the word mora, kapag delay, mapapamora ka. Okay, pasensya na kayo ha. Medyo corny yung joke. Pero, yan. Kapag may delay, may mora. Okay? So, delay should be differentiated with ordinary delay. Ordinary delay simply means failure to perform an obligation on time. But there is no breach of obligation yet. At least not yet. You have to make a demand first para maging legal delay yung ordinary delay. Okay? So, ano ba yung legal delay? O halimbawa, ganito. Si A nangutang kay B ng 5,000 pesos. Ang sabi ni A, okay, babayaran kita next month. Kung nagutang siya is January 1, ang sabi niya, babayaran kita ng February 1. So, noong February 2, hindi pa rin siya nagbabayad. Ang tawag lang doon ay ordinary delay. Ngayon, kung nagpadala ka na ng demand letter, either, sabi dito kasi, either through judicial or extrajudicial demand, para sa akin, malamang extrajudicial demand ito kasi kapag sinabing mong judicial demand, nasa korte ka na di ba? So, extrajudicial demand lang. Yung extrajudicial demand na yun, pwede ba yung verbal or written? According to the law, wala namang distinction. So, pwedeng verbal, pwedeng written. Pero, in matters of evidence, paano mo nga naman ipoprove na nagdemand ka verbally? Kasi wala ka namang evidence, di ba? So, mas maganda parati written yung demand letter mo. And mas maganda kung ipapa-course through mo yung demand letter mo sa kagaya kong abogado para magkaroon ng impact. Kasi kadalasan kapag yung ano lang yung nagpapadala, yung claimant, ni-ignore lang din Okay, next slide na tayo. So, there are 3 types of delay actually. So, you have your mora solvendi. This is delay on the part of the debtor. Mora accipienti is delay on the part of the creditor to accept performance of the obligation. So, yung mora solvendi, yan yung pinakauso. Yung debtor ay nag-delay siya sa pagbabayad. Yung mora accipienti naman is yung delay sa part ng creditor upang tanggapin yung bayad. Ngayon, alam mo, habang binabasa ko to, parang it doesn't make sense. Kung ikaw yung pinagkakautangan, ikaw yung creditor, bakit i-reject mo yung payment sa'yo ng obligation ng other party? So, sa nakikita ko, ang isa sa mga posibleng dahilan is gusto niyang umakyat pa yung interest rate. Diba? Kasi kung mas mataas yung yung pagkakautang, edi mas mataas yung interest rate, 'di ba? And at the same time, kung nakapagbayad ng utang, edi wala ng interest, 'di ba? So, yun siguro yung dahilan kasi gusto niya umangat pa yung interest, 'di ba? E paano kung gusto na bayaran ng buo nung seller? Ay nung nung debtor, 'di ba? Kapag malaki ang pera yan, baka mas malaki ang din yan, interest rate. Compensation more, so both parties delay. So pareho kayo, nag-delay kayo dun sa reciprocal obligation. So we get it. No demand, no delay. But are there instances wherein demand is no longer necessary to put the debtor in delay? The answer is yes. In Tagalog, ang general rule, no demand, no delay. Exception, ibig sabihin nitong exception is hindi na kailangan ng demand. Meaning kapag lumagpas na siya dun sa oras, automatic delay na. Ang tanong is, may mga scenario ba o sitwasyon ba na kagaya ng ganito? Ang sagot is yes. So, number 1, when the obligation or the law expressly so declares na hindi na kailangan ng demand. Number 2, when the nature of the circumstance of the obligation, it appears the designation of the time when the thing to be delivered or the service to be rendered was a controlling motive for the establishment of contract. That is yung birthday cake, kung may birthday yung tao, or yung wedding gown, kung may wedding yung tao. O imaginein mo naman, 'di ba? Nag-set ka ng kasal, tapos wala ka palang wedding dress on the day of your kasal, 'di ba? Magpapadala ka pa ba ng demand letter? Ang sagot hindi na. Kasi the nature and the circumstances of the obligation, it appears that the designation of time was the controlling motive. In fact, kaya ka nga nagpagawa ng wedding gown kasi gagamitin mo yun sa kasal, 'di ba? O kaya ka nagpagawa ng birthday cake kasi gagamitin mo yun dun sa birthday ng tao. When demand would be useless as when the obligor has rendered it beyond his power to perform. Okay, Article 1170. Those in the performance of their obligation are guilty of fraud, negligence, or delay, and those who in any manner contravene to the tenor thereof are liable for damages. So again, 1170 talks about damages. Okay, I think we discussed this a while ago. Damages are brought about by 4 things. Okay, so ito yung mga bagay na kung saan pwedeng mag-seek ng damages ang isang tao. Number 1 is fraud or deceit. Ang tawag dito ay dolo. Fraud or deceit, dolo. May dalawang klase pa ito, pero hindi ko na muna i-discuss ngayon para hindi kayo masyadong malito. Negligence naman is culpa. Okay? May kapabayaan ka. Culpa. And then number 3 is delay. Ito yung mora. Number 4 is contravention of agreement. Okay? Next slide. Responsibility arising from fraud is demandable in all obligations. An action for future fraud is void. Responsibility arising from negligence in the performance of every kind of obligation is also demandable, but such liability may be regulated by the courts. What are the 3 types of negligence? So, ito yung sa culpa kanina, di ba? You have your negligence in contracts, that's culpa contractual. Number 2, negligence resulting to damage. Ito yung tinatawag nating quasi-delict. Negligence ka, tapos nagkaroon ng damage. Dito wala namang kontrata. Okay? So, ang tawag dito ay culpa aquiliana, otherwise known as quasi-delict or tort. Okay? And then yung number 3 is yung criminal negligence. Negligence resulting in the commission of crime. So, an example here is yung reckless imprudence resulting to damage to property or to physical injury. Kasi, yung physical injury or homicide, ano yan, criminal in nature yan. Yung damage to property, pwede mo siya siguro i-categorize as I think kapag damage to property, papasok na yun sa civil negligence. Pero, may provision kasi under the revised penal code na nagko-cover ng reckless imprudence resulting to damage to property. Kaya, nandito siya sa criminal negligence. Specifically kasi nakalagay yan sa sa revised penal code. Yan yung criminal code natin. Okay? But nobody really calls it criminal code. Unlike, di ba, civil law is civil code. Sa criminal law, you have your revised penal code. Okay? 1173. When the fault or negligence of the obligor consists in the omission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of the persons, of the time, and the place. So, when negligence shows bad faith, the provisions of Article 1171, 2201, and Paragraph 2 shall apply. Okay, what is fault or negligence? Negligence is the failure to observe the protection or of the interest of another person, that degree of care, precaution, and vigilance which the circumstances unjustly demand, whereby such person suffers injury. Okay? Fault or negligence, kapabayaan yan. Fault or negligence. In Tagalog, kapabayaan. 1174, ito, very, very sikat din naman ito. So, dapat alam nyo to. Fortuitous events, except in cases specified by law, or when it is otherwise declared by stipulation, or when the nature of the obligation requires the assumption of risk, no person shall be responsible for those events which cannot be foreseen, or though foreseen were inevitable. So, interesting ito kasi kapag binasa mo yung Article 1174, nauna yung exception bago yung general rule. So, ano ba yung general rule? The general rule is that, ito, no person shall be responsible for those events which could not be foreseen, or though foreseen were inevitable. Ang tawag dyan sa events na yan ay fortuitous events. Ito yung mga bagay na hindi mo talaga makikita na mangyayari, or even if nakita mo mangyayari is hindi mo talaga mapipigilan. Halimbawa, yung mga earthquake, di ba nakikita mo mangyayari yan? Or well, sometimes hindi mo talaga nakikita. O kaya mga typhoon, mga tsunami, nakikita mo yan siguro mga 3 hours before. Pero at that time, parang mahirap na maiwasan di ba? So, fortuitous events. Okay? So, general rule, walang liability yung debtor. Okay? But, may exception, which is yung those expressly specified by law. Again, ang laging exception dito na makikita mo is yung exception based on law, exception based on contract. And then yung number 3 dito, which is unique, the nature of the obligation requires the assumption of risk para sa fortuitous event. Okay? Next slide na tayo. What is a fortuitous event? A fortuitous event is any event which cannot be foreseen or which though foreseen is inevitable. So, a fortuitous event may either be either an act of man or act of God. So, sa act of man, war, fire, and robbery. Act of God, earthquake, flood, and typhoon. So, ito yung mga bagay na hindi mo talaga mapipigilan. Kung mangyayari sa'yo ito, hindi mangyayari talaga. Diba? So, the general rule, a person is not liable for loss or damage due to non-perfection of this, due to fortuitous event. Exception here, even if there is a fortuitous event, the debtor is still liable. Ito yung mga law. Number 1 is law. Number 2 is contract. Number 3, the nature of the obligation requires assumption of risk. So, dito sa assumption of risk, ito yung mga sa insurance company, di ba? In case of flood, babayaran ka. Diba? So, ibig sabihin yan, may assumption of risk, which is yung risk na magkaka-flood. So, kapag ganyan, yung obligasyon mo, hindi mawawala. Tuloy-tuloy pa din. 1175, usurious transactions shall be governed by special law. Ano ba yung usury? Okay, so bago natin discuss yun, aralin muna natin. Simple loan or mutuum is a contract whereby one of the parties deliver to another money or other consumable thing upon the condition that the same amount of the same kind and quality shall be paid. So, ito, yung simple loan or mutuum, yan yung utang. Okay? So, may dumagdag na naman sa vocabulary mo, mutuum, di ba? Parang masarap kainin, ano? Mutuwam. Parang ano, no? Japanese food. Okay. So, yung simple loan or mutuwam, utang lang yan. Okay? So, ngayon, ano ba yung usury? Usury is contracting for or receiving interest in excess of the amount allowed by law for the loan. So, nagbabasa ka ng Bible, parang ito yung mga high interest rate na kumbaga kinasusuklaman nung unang panahon kasi napakataas daw nila magbigay ng interest rate. Okay? So, usury or usurious transaction, yan yung matataas talaga yung interest rate. So, usury is the practice of making unethical or immoral monetary loans that unfairly enrich the lender. The term may be used in a moral sense, condemning taking advantage of others' misfortune in a legal sense, where an interest rate charged is in excess of the maximum rate that is allowed by law. Okay, so dati meron tayong maximum interest rate allowed by law. Regulated yan ng Bangko Sentral of the Philippines. Pero, ngayon, na-amend na. Ito pala, is usury illegal in the Philippines. The Philippines used to have an anti-usury law that sets a cap on the interest rates on loans. So, dati, may batas talaga na nagsasabi, hanggang dito lang yung papautang mo. However, this was suspended in 1983, and the efforts to revive the law have languished o hindi natutuloy sa Kongreso. It was scrapped on the belief that the court can decide whether or not an interest rate in a loan agreement is acceptable once the case is brought before it. So, ngayon, ang determine lang whether or not mataas talaga yung interest rate is yung korte lang. Diba? Pero pag titignan mo, napaka-hassle nun. Para lang questionin mo kung mataas ang interest rate, kailangan mo patang pumunta sa korte. Ibig sabihin, magpapiling fee ka na naman, kukuha ka ng lawyer, etc. So, ang haba ng proseso. The stipulated interest rates are illegal if they are unconscionable. Again, ano ba yung unconscionable? Beyond the conscience. Napakataas. Kaya unconscionable. Okay? So, may bagong word na naman tayong natutunan. Unconscionable. Sabihin sa halimbawa ng isang kaibigan mo, bro or sis, mare, pwede bang umutang? Sabihin mo, magkano ba? Sabihin niya, ano lang, 5,000. O ngayon, pwede mong sabihin mahal naman. O pwede mong sabihin, napaka-unconscionable naman yan. Actually, ang 5,000 hindi siya unconscionable. Medyo mababa. Pero siguro unconscionable siya relative to the person who's trying to lend it. Diba? Ayun. Napakataas. Okay. Central Bank Circular 905 suspended the usury law. So, wala na tayong batas against usury. So, pwede ka na magpautang ng kahit anong interest rate ang ilagay mo basta magkasundo kayo ng other party. Okay? The receipt, Article 1176, the receipt of the principal by the creditor without reservation with respect to the interest shall give rise to the presumption that the interest has been paid. Okay? 1177, creditors after having pursued the property in possession of the debtor to satisfy their claims may exercise all the rights and bring all the actions of the latter for the same purpose save those which are inherent in his person. They may also impugn the acts which the debtor may have done to defraud them. 78. Subject to loss, all rights acquired in virtue. I think it should be by virtue. They should be by virtue. By virtue of an obligation are transmissible. If there has been no stipulation to the contrary. So what you have to remember is your right is always transmissible. Okay, but there are some rights which are not transmissible. The right of a partner in a partnership agreement is not transmissible. So this is I'll jump very quickly to partnership law. Sa partnership law kasi parties must maintain trust and confidence with each other. Kapag broken na yung trust and confidence, pwede na ma-dissolve yung partnership. So hindi mo pwedeng i-delegate yon sa ibang tao. Okay? Right of an agent and the contract of agency is also personal. Cannot be transferred. Okay? Okay, that's it. That's end of chapter 2. Oh gosh, it also almost took me an hour. I hope you learned something from here. Okay? That will be all for now. Thank you.